So on to the beginning of the presentation. First, on behalf of my colleague Mara Sen and I, we welcome you to Arnold & Porter. We're very glad that you are able to join us for this program. The program is entitled What Your Company Needs to Know About the Current State of SEC Conflict Minerals Regulations. As we mentioned, for the 70 or 80 of you who are listening, please use the chat feature tool within WebEx to ask questions throughout the program. Due to time constraints, we might not be able to get through all of the questions, so please do not hesitate to contact any of us directly if there are things that weren't covered. Your lines have been muted, but if you need assistance during the conference, press star and then 0 on your telephone, and a conference coordinator will be happy to assist you. This event is being recorded and may be posted on the Arnold & Porter website, where it will be made available to the public. For your convenience, shortly after the program, we will send a link with the presentation materials to all of the participants of today's program. So on to our program. Those of you in the room have a booklet of materials with the slides that we'll be going through, and as I mentioned, we'll be sending them electronically shortly. Just to all of you who are on the phone, to set the stage a little bit for our presentation, I'd like to say a couple of words of background about the rules to put them in context. And I'm one of the few people that dealt with this issue while at the State Department. I was with the State Department for 22 years, and in 2 of my capacities there as a lawyer and later heading the U.S. refugee program, I dealt with the issue of displacement of people from Central Africa and some of the consequences of the violence. So it was a particular interest to me to come back into this issue from the perspective of the Dodd-Frank rule and the SEC's struggle over 2 years to develop its regulations. For those of you who are on the phone in particular, some of whom I understand may not have part of the history, I'll just read you about 30 seconds of history of this and then turn the presentation to my panelists here. On August 22nd, 2012, the SEC issued a long-awaited final rule under Section 1502 of the Dodd-Frank Consumer Protection Act relating to the use of conflict materials. The final rule, which under Dodd-Frank should have been issued April 15th, 2011, is intended to reduce the flow of funds from the extraction and sale of certain minerals that have been used to finance armed conflict in the Democratic Republic of Congo, DRC, and surrounding countries by increasing accountability for parties involved in the supply chain for these products. And to give you some statistics, and we were talking in the room here in advance of the session of the huge impact of this very complicated rule, an estimated 6,000 companies will be required to file annual reports with the SEC to review their supply chains and publicly disclose their use of tantalum, tin, tungsten, and gold if any of those materials are necessary to the functionality or production of a product that they manufacture or contract to manufacture. Mara will be giving some of the details about the rule and an update on the current litigation regarding it. So I'll stop with my background, turn it over to Mara. And what I think is most efficient, I will just say a word about each of the panelists, and the order, we read Mara, John, and then Kristen. Mara Sen, Arnold & Porter partner based in the DC office, is a trial lawyer who focuses on white-collar criminal law, international arbitration, and other regulatory issues. She's litigated in the U.S. District Court, Court of Appeal, and the U.S. Supreme Court, as well as various international fora. Her practice is incredibly diverse, including issues of corporate social responsibility like the conflict minerals, to traditional litigation, white-collar litigation, and corporate compliance. So Mara will be able to give us an overview of the law and some of its implications. John Gabriel, sitting to my left, serving on the board of directors of the Electronic Industry Citizenship Coalition, EICC, and is the chairman emeritus of its board of directors. EICC is a 75-member global organization focused on the supply chain code of conduct and implementation tools for the electronics sector. John is also corporate manager of IBM's Supply Chain Social Responsibility Program. He was appointed to this position in January 2004 and oversees a global team responsible for IBM's Supply Chain social responsibility initiative. Tremendous enterprise. And finally, Kristen Sullivan is a member of Deloitte's Sustainability Services and works with clients to help address their sustainability needs, focusing primarily on sustainability reporting and assurance matters. She brings extensive experience in sustainability reporting, specifically focused on social impact. Kristen, in fact, leads Deloitte's efforts in support of social impact investing, specifically focused on Deloitte's services in support of the Global Impact Investment Rating System, GIIRS. Significantly, for today's program, Kristen heads Deloitte's Conflict Minerals Advisory Services, so has particular insights and is a real leader in this field. And we're very happy to have both John and Kristen join us today. And with that, I'll ask Mara to go ahead and set this up.
Great. Thanks, everybody, for participating, and I'm really excited to be on a panel with these guys because the nice thing is, I'm a lawyer. We're kind of a dime a dozen, although I like to think I'm unique in some ways, but these guys really have actual knowledge, and John is even an engineer, so he actually really knows stuff. So, so what I'm going to try to do is just, for those folks who aren't as familiar with what this rule even means, I'm going to do an overview of the SEC rules, the current state, and then I'm going to talk a little bit about the current state of conflict minerals litigation, and then just talk about what it is that lawyers do in connection with these issues. I only have, I'm going to do a disclaimer, I only have 10 to 12 minutes, and Sam will cut me off if I go even a second over, so I'm going to try to, I might not be able to cover everything, but, we're happy to answer questions at the end. So as Sam said, this was a recently issued rule. Many people, including those in this room, question why it was even put within the bailiwick of the SEC. And really the answer is because Dodd-Frank was a huge monster and everybody else was completely filled up, and they said, let's just give it to the SEC. I deal with the SEC a lot on the FCPA issues, so I'm familiar with the way that they work, and they're not always the most effective organization, and I think that it's particularly challenging for them to deal with this rule, which is completely outside of their core mission, and has been very controversial. They took an extraordinary amount of time to even come up with the final rules, and then the final rules basically said we're not defining anything. So, those are sort of the overview of some of the complications. So the first step, if you're a company, is do the rules apply to you? The second step is that if you determine they do apply to you, you need to do a reasonable country of origin inquiry, and then step 3, you have to perform due diligence to figure out where they're actually from. Okay, so the first rule, does it apply to you? Oh, and this is the seal of the SEC, just, to make it legit. Okay. Okay, so step 1, are you covered? So basically you have to be an issuer, and some of we'll address some of the people who are not issuers, but will still be severely impacted by this rule. But in order to be subject to these rules per se, you have to be an issuer, and you have to manufacture or contract to manufacture a product for which conflict minerals are necessary to the functionality or production of that product. Now, each of those subparts if you're an issuer or not an issuer, presumably you already know that, so that's the easy part. The more complicated part is the rest of it. So manufacture or contract to manufacture. The conflict minerals are the 3 T's and G, which are tantalum, tin, tungsten, and gold. And the covered countries that people care about where they're from is essentially the DRC and then the surrounding African countries. There are some small exceptions. It doesn't apply if it's outside the supply chain prior to January 31st, 2013, and it doesn't apply if it's from recycled or scrap materials. But really, for most companies, the most complicated provisions are if you're a manufacturer, again, it's pretty easy. If you're a manufacturer, you're covered if you're also an issuer. The contract to manufacture is one of the most contentious issues around because the SEC didn't really define what that means. So, if you require somebody to manufacture something to you, if it's something that's completely off the shelf, you don't interact with anybody, you just walk into a store and buy it, you're not contracting to manufacture. And then if you manufacture, that's on the other end, you're obviously a manufacturer. Anywhere in between is undefined, essentially. So there's a sliding scale of the more control you have over the content and the design of the product, the more likely you are considered to be contract to manufacturer. But this is one of the really undefined areas. And it's a place where, for most of our clients, it's a combination of an interpretation of the rule and the risk tolerance of the company. So some companies want to aggressively exclude things from the rule, and they draw a line in one place. Other companies want to over-include just in case, and so we help them in both situations. The other issue is whether or not it's necessary to the functionality of a product, which is essentially if it's part of the function, use, or purpose. If it is intentionally added to the product, and if a conflict mineral is intentionally added to the product, then obviously it's covered. And if it's added for ornamentation or decoration, and that it is a decorative piece, so it's part of the functionality. Again, what does that mean? I mean, if you add it to decorate, presumably you're doing that for a purpose, so probably it is going to be included. So the one thing that there are a few exclusions, like for example, if all you do is a byproduct is used for a catalyst, or tools are used that have conflict minerals, but in the end product does not have conflict minerals, that is not within the rule. Okay, so now you have, and one really, really important thing is there's no de minimis exception. So no matter how small of amount of one of these minerals you have in your product, it is covered within the product. So the most absurd, I've heard a lot of absurd examples of this, but the most recent, most absurd thing that I heard was that in certain dyes in clothes, there are minuscule, microscopic, in certain colors, I think it's tungsten, and so are within the dyes. So you could have a completely cotton shirt, but it happens to be yellow, and that yellow has an infinitesimal amount of tungsten. Technically, that is within the purview of this rule, which is crazy on a number of levels. Okay, so let's assume that you are covered, that your product is covered. Now what do you have to do? You have to do a reasonable country of origin analysis inquiry. Now, of course, as with everything else in this rule, the SEC doesn't actually tell you what that is. You just have to kind of figure it out. So one of the challenges is that, well, one challenge is figuring out whether or not your dyes have infinitesimal amounts of tungsten in them. But one of the other challenges, I mean, if you have complicated products with many, many different components, like, for example, an IBM would, you need to figure out whether or not those minerals, you have to figure out, first of all, are those minerals in each of those products and each component of those products, and who do you ask about them? So basically, you need to go back to your suppliers, and this is where the non-issuers come in. You have to go back to your suppliers and trace all the way back. Again, in some instances, it's going to be easy. If you're a ball bearing company and you source from a smelter, you go to the smelter and you say, where did you get your metal from? If, on the other hand, you're an electronics company and you have 13,000 pieces in one computer, you're going back to all of your suppliers. Well, first of all, you're trying to figure out whether or not your products, that's step one, whether or not your products have these minerals within them. And then the next step is, where did those minerals come from? Now, as everybody knows, can be an extremely complicated inquiry. I mean, there could be thousands of suppliers, and you might have to go back 10 levels just to actually get to the smelter, much less from where the metals come. So it'll be interesting to see. A lot of people are claiming, and with great justification, I think, that there's absolutely no way you can figure out where these things are from. If the products are covered, but they didn't, and you can determine that they did not originate in one of the covered countries, then you file something with the SEC just saying, we figured this out and we decided that it's not within the problematic countries. If, on the other hand, you decide they may come from one of these covered countries, then you need to do due diligence. And Kristen is going to tell us exactly what that entails. But basically, again, there's no specific thing you have to do, but you're supposed to just figure out where does it come from? Is it from the precluded countries? And then at the end of this, you have to, and it could be that you don't really know. You're not sure, and you have to have due diligence to figure out where these countries are from. So at the end, you would have to, after your due diligence, you would file a report, and you would describe the due diligence. You would describe the products found not to be DRC conflict-free. You would talk about the facilities used to produce the product's conflict minerals and the country of origin of these minerals. And you could either find that the conflict minerals are not from covered countries, that they're DRC conflict-free after all, they're not DRC conflict-free, or they're undeterminable. So for the undeterminable, pretty much everyone's going to just invoke that. For 2014 and 2015, you can say, we tried, but we just can't figure it out. And for small companies, smaller reporting companies, they actually have 4 years where they can say this. But eventually, they're going to have to put in some kind of substantive report.
Advance the slides.
Oh, yes. Sorry, that's true. Okay, so, and everybody will get, I just talk and talk, but people can, yeah. Okay, next up for filers. So the Form SD is due May 31st, 2014, which covers calendar year. It's based on a calendar year, regardless of what your fiscal year is, so calendar year 2013, which means that companies really have to start thinking about this sooner rather than later, because it's going to take a while to contact the suppliers. The suppliers won't get back to you. You're going to have to follow up with them. And just a word about the suppliers. Even if you're not subject to the rule because you're not a supplier, I mean, you're not an issuer, if you provide products to people who are issuers, to companies that are issuers, they are going to ask you for information. So it's helpful if you know that that's going to be the case, to get out in front of it and basically do the inquiry already. And John is going to address, I mean, just look into the issues that are in the EICC questionnaire, because that has become sort of an industry, not even an industry, it's really like a everybody standard form. And so if you're a supplier and you at least have the information in that questionnaire, you're going to be most of the way there. Okay, now, many people were upset, if not horrified, by these regulations, and some people took some steps about it. So there's a challenge currently pending in the DC Circuit, brought by the National Association of Manufacturers, the U.S. Chamber of Commerce, and the Business Roundtable. The briefings have been finished for this case. It's actually on an expedited schedule, so the oral argument's is going to be May 15th, 2013. And the circuit is obviously aware that these are pending regulations that are currently in force. The petitioners actually argued to suspend the application of this rule, but that motion was denied, so they're still currently in effect. So the DC Circuit knows that this is a time-sensitive issue. You never know when they're going to issue their opinion, but hopefully it'll be sooner than they normally would, which could mean 2 or 3 months, which would bring us June, July, August, which would give everybody a full 3 months to respond. Okay, so the substance of the challenge is, and really the core thing is, there was an inadequate cost-benefit analysis, meaning that there's no indication that the DRC is even going to benefit from this. In fact, there are people who believe that it's gotten worse because people don't want to do business in that region and it's become more impoverished. So in addition, they said that the SEC didn't take into account how much it would cost companies. They also challenged the failure to include a de minimis exception, and I think the most significant challenge is the disconnect between the statute, which said did originate, and the regulation, which says that did originate in the covered countries, and the regulation, which just says reason to believe may have originated, which is a much broader standard. They also argue tracing the full supply chain is unreasonable, that contracted manufacture goes beyond the statute, although, interestingly, in the briefings, the SEC points out that Congress actually did mention in a number of places in its law and reports that contracted manufacture was also part of it. That it's problematic that they gave a shorter transition period to larger companies, and that it also violated the First Amendment by compelling speech. Now, the core problem with this challenge is Congress. So what this case is doing is it's challenging the implementation by the SEC of Congress's statute. Well, really, what essentially they want to do is they want to challenge Congress's statute, but they can't really do that. And so what they have to show is the SEC essentially violated its standard of care and its obligations to implement this statute fairly, almost with the exception of the did originate in reason to believe, may have originated, and possibly the cost-benefit analysis. All of the rest of it is really, they just essentially did what Congress told them to do. Arguably, in the other, they're supposed to have a cost-benefit analysis to sort of do a check on Congress, and they took the did originate further than it actually said. But I think ultimately, if the petitioners were to win in this suit, a lot of other regulations would fall. So, for example, they say it's First Amendment violation to require these filings. Well, there are many, and the counter argument is, well, these filings are just purely factual. They're not requiring you to make any speech, just as you have to do your 10Ks and your 10Qs. That's you're obligated to do that. That's just sort of the pact you have. If you are allowed to list on U.S. stock exchanges, you have to conform to the rules. So I think it's unlikely that the claimants in this case will prevail. So what I think will happen is that maybe the D.C. Circuit will admonish the SEC to be more clear, or will put some kind of editorial content into their decision, but I don't think they'll overturn it. And then I think right now the SEC is loath to do anything to issue more guidance because it might affect this pending case. I think once the pending case is over, the SEC has gotten so many comments and so much feedback about how vague they are that I think they will ultimately issue guidance, but it can only be after the D.C. Circuit issues their opinion, which doesn't give companies very much time to comply with not only whatever exists and whatever comes out of the D.C. Circuit, but any new SEC regulations. That being said, and we'll hear more about this from my colleagues to my left, that being said, I think these regulations are here to stay, and I think that it's important that companies prepare and start doing this due diligence so that they're not caught unawares at the end of the year.
Thank you, Mara. John?
Okay, I will briefly take us through kind of moving ahead from Mara's presentation to maybe some more of the mechanical aspects of this work once you've gotten yourself a little further into that investigation. So the material that I will present is presented on behalf of the Electronic Industry Citizenship Coalition / GESI. Global E-Sustainability Initiative is the other trade group that we worked with to create these materials and these tools. Our engagement in this issue goes back quite a while, to actually 2007. A little history on the EICC and how we actually got involved in this matter. Firstly, we came together in the year 2004 as an industry group. At that time, we weren't yet incorporated as industry group, but the beginnings of that. Within the electronic sector, we began to get a lot of focus from non-governmental organizations, or NGOs, on the topic of supply chain social responsibility. The NGOs of the world have kind of progressively moved through different sectors, highlighting issues in the supply chain. First started with shoes, then apparel, then agriculture, and finally electronics in about 2004. So individually, companies in the electronics sector, and I can talk about IBM, which is 28 years of where I've been, we had vestiges of supply chain social responsibility throughout our procurement practices, but we never called it that, right? We didn't have anything coalesced. So in 2004, when the NGOs began to take an offensive on the electronics sector, what they started to do was to raise public attention to say, well, the companies in this sector look very pristine, right? You talk about IBM or Motorola, and you think these are wonderful products from shining factories in the Western world. Well, guess what? It's not that way, right? These companies may design things here, but things are made in faraway countries, often right next door to the same shoe factory that has child labor. So that was kind of the premise that was put forward in the public space in 2004. So companies began to react individually, but luckily in a parallel world, we also met kind of off on the side and said, well, for us in electronics, we tend to be very efficient-minded companies. So we looked at this and said, this could get out of hand quickly, right? If we had 10, 20, 50 companies out there with codes of conduct, we're going to be going to the marketplace and essentially infusing potentially a lot of duplicate effort. So wouldn't it be great if we could step aside and figure out a common code of conduct for the sector and then ultimately ways to implement it? So that's actually what we did do. So we've created, back in 2005, the one called EICC Code of Conduct. It's a social responsibility code. Talks about labor practices, ethics, environment, health and safety, and management systems. And we created an entire audit protocol around that so that companies, members, and their extended supply chain can use this common set of tools to go out, assess suppliers, and ultimately make improvements on the journey towards code compliance, which, if fulfilled, should improve the social environmental position of the extended supply chain. So along the way, in about 2007, this topic actually came on the radar screen. We meet as an organization face-to-face now 2 times a year for about a week at a time. And part of what we do as an organization is we just have an open session and say, what's anybody hearing out there, right? What's the next issue we're going to have to deal with? This actually came up. Some companies said, well, we're starting to get inquiries from NGOs. Are you doing anything in Central Africa, right? Did you know about tantalum? Did you know about this, that, and the other thing? So we looked at this and said, this is coming our way. So instead of doing a typical industry reaction of trying to deflect this, we said, you know, a lot of us are technical people. We know these materials exist in our products, right? This is not a lot of, well, does it apply to us or not? We recognized early on, one way or the other, this is going to affect us. So let's get in front of this instead of maybe trying to deflect it. So we started to put together some research. We spent about 2 years researching 10 materials, of which 4 of those 10 ultimately ended up in Dodd-Frank. And what we did for ourselves is we did the research on these 10 materials to try to prove to ourselves, well, how much of this stuff do we really use? Before somebody says it, let's prove it to ourselves. So it did turn out that of those 4 materials, electronics, in the broadest perspective, is the major user of tantalum. So if you have any electronic product, chances are it's got tantalum in there, predominantly in capacitors. The next one, tin, we're also a major user, not the major user, but a major user. Interestingly, because of an initiative 10 years ago that talked about getting lead out of solder, the substitute material ended up being tin. So I worked on getting lead out of products 10 years ago, and then woke up to tell the product that we substituted is now engaged in this. So if you stay in a job long enough, this is what happens. Right? What you fixed comes back in another form. Tantalum to a lesser degree, and gold surprisingly very little, because it's a precious, very precious metal. It's only used predominantly in some fine wire connections and in any mechanical connector. So that was our history on this. So we said, okay, let's start to do this assessment. And what we did, and this is kind of a simplistic chart, but if you consider an OEM or a brand on the right-hand side of your chart, we did some research that shows in the electronics sector about 8 layers of the supply chain separate a brand company, which is somebody that's selling something into the marketplace, and the actual point at which the material is being extracted out of the earth. Okay, so there's a pretty significant supply chain challenge, and in the almost 30 years I've been in procurement, this is the most detailed supply chain activity that I've ever been a part of. So you say, well, where do you start? For us, what we were able to determine here was about halfway through that supply chain are companies called smelters and refiners, and for this issue, that's your pinch point. Because that's the point at which all the raw materials, after they've been handled and maybe concentrated and somewhat pre-processed, come into a factory and they're literally melted down. So you lose the identity at that point. And then everything that happens upstream of that, you're not necessarily sure with any certainty where it all came from. So you really, in this case, have to focus on the smelters and refiners. And underneath there, you see those 3 rectangles. We've created tools and applications to address every one of those sectors. So where we first put our focus is in the middle there on what we call the conflict-free smelter program. So what we did, we took our supply chain social responsibility audit program and we sort of modified it to fit the smelter environment in specific to materials, conflict minerals. And we came up with an audit process here that really looks at 3 things. We've created the physical audit where companies will go out to a smelter, to a refiner, and they will look at these 3 things. The ultimate goal of this is if you pass all 3 of these, you end up being called an EICC certified conflict-free smelter, which essentially means you have a policy to prevent conflict materials coming through into your process, that you have a mass balance where you're able to track everything coming into your facility and ultimately everything going out, and that for all of your inbound materials that you have an adequate level of documentation. And depending on, and this is actually broken into these 3 levels, depending on where the country of origin is, the audit process is attenuated to increasing levels of documentation and what's actually looked at in the audit. So in a level 1, these materials could be coming into a smelter not from the DRC or the adjoining 9 countries. And this is kind of one of the confusing aspects of the law that was written. These 4 materials by nature are called conflict minerals. It doesn't mean they've come from the DRC or the 9 adjoining countries. It's kind of guilty until proven innocent, right? These 4 materials can come from many other places in the world. So if you're a smelter and you can prove that, well, I don't get anything from these 9 countries, you can go through this audit program rather expeditiously. But it also allows smelters to actually use materials from the region. Because as Mara said, this is one of the challenges of the law. We did not want, or industry didn't want this to become unintended consequences. Because the easiest thing you could do here is cut and run and say, well, I'm not going to get anything from the DRC. I'll just put out a bulletin notice. I'll just make sure, to the best of my ability, nothing will come from there. Well, the problem with that is then you're going to create a secondary problem because the artisanal miners in the DRC, in particular the eastern half of the country, this is all they have to survive, right? So if we take this away from them, now we've got another humanitarian issue of a couple million people with absolutely no means to support themselves. So this is not necessarily about do that and you fix the problem. So we've created the process that will allow you to actually buy materials from good, small artisanal mining operations in that region. Now, the flip side of that is if you do that, that's L2, L3, right? There's increasingly higher degrees of documentation that you have to have there. Now, this is actually a very simplistic chart. This shows the as of a week ago, where we're at on the CFS program. So by material, in the top line are the number of smelters that have entered into the process. The second line there are the numbers that have been listed on our website as certified compliant. So there are today 17 tantalum smelters that if you're interested in buying tantalum that has a certified non-conflict source, you can go out to that website when you leave here and you can find the names of those companies and the smelters that process that good material. Similarly, there's 12 gold refiners. There are 3 tin smelters that have gone through the process. They just haven't been publicly listed yet. So that website you can go to. There's no charge to get there. You may just have to answer a questionnaire, and that'll give you the names of those companies. So what the importance of that is you're a company, as you go through your due diligence, ultimately what we're setting up here is the foundation, the groundwork of smelters that through your purchasing organizations you could direct them, and that through their contracts they could stipulate to their upstream suppliers or to themselves to only buy materials from those certified sources. Now, there's still a third element of this, is the addition of due diligence. To get to those smelters, well, how do you get there? Well, if you're a brand, and at the graphic there you'd be near the bottom, say a customer, we've created a standard format whereby you through your purchasing organization can begin to send this out to your suppliers, your direct suppliers. And this is also on the internet. It's free. You can download this. This is just a screenshot. It's a simple Excel format. Simple in the sense that it's fairly easy to use. Not so simple in that it took us about 2 years with 80 companies to figure this out, right? But we have done that, and it's become kind of the de facto standard, not just in electronics, but in other industries as well, to use this as a common means to communicate to your next tier supplier. And what it allows you to do is to go in there and fill out information relative to, say, I'm IBM and I send this to my first tier company that makes subassemblies. They put their name in this, and then they begin to go through and declare if that what they sell us has any of those 4 materials, and then subsequently, do they know where that comes from? To answer that, they in turn have to send this to their next tier. Their next tier often has to send this beyond, to the point where you can actually get and start to fill out the names of the smelters. And that's that pinch point again. Now, with that list of smelters, then, well, what do we do with that? Well, 2 things. Companies can use that and to go directly to those smelters and say, well, you are in my extended supply chain. I would like you to go through this certification program because I'm going to be filing. I would like to know that what I'm getting from you ultimately is coming from good sources. It also allows us as the industry group to compile this and to create the best knowledge base of where are all these smelters around the world. Because that was not a given at the beginning of this challenge. You know, that was not one of the things you could go to the shelf and pull off the Thomas's Register of all certified or all smelters in the world, right? In fact, this has been like a great CSI case. A lot of the supply chain in this end-to-end program did not want to be recognized, does not want to participate, right? There's a lot of trading of materials that goes on. There's a lot of things that a lot of people were happy to remain in the shadows with. So this is not something where everybody's running to your desk with all the information, right? You have to have the perseverance and the time to go through this very meticulously. So as an industry group, it helps us to compile all this over the course of time to try to create that database. Now, we've also allowed, or we've provided an aggregation tool that if you're a company distributing this survey to 5, 10, 15, 20, 30, 100 upstream suppliers or more, we have a simple compiler that allows you to amass all this information. And for confidentiality, what it does, it takes out the names of all your suppliers. So say if you're IBM and you've sent this out to 350 companies, when I go through the compilation, because I need to provide this to my customer, it erases the names of all my suppliers, but yet it brings in all of the smelters and all of that country of origin information. So when you've done this, now if you've done, like I have to 350 companies, your compiled spreadsheet ends up being thousands of lines long, right? And then you can work to, take out the duplication and so forth and kind of refine this down. And that's the thinking behind this, is it's a progressive approach with this template, that it continues to consolidate till you get to the final brand or the company that's going to put this product into the marketplace. So ultimately, that allows you to go through and prove your due diligence. Now, the truth that if to go through a reasonable country of origin inquiry, many companies are using this to try to get to there as well, because reasonableness wasn't defined yet, and at some point I have to sit down with the likes of Kristen and say, well, how did you prove this, right? What was your thinking, right? So that is our logic, because we've presupposed those four materials are in our product. So we think we're in the potential field of play here. So we've taken these tools and we're using those as kind of our first cut on our COI to say, yes, we have to go beyond, and then move right into the due diligence piece. So there's probably a lot of other things I could talk about, but I'm going to save some of those because people have actually asked some questions for some of the things, and in the interest of time, we'll wait till we get to that point. So I'll hand this off to my colleague here, Kristen, for the next pieces.
Before Kristen starts, Sam Whitten again, I just wanted to say that we have received 3 additional questions from the 70 or 80 people who are listening. We will keep accumulating them, and we'll do our best to reply to them. One may require separate consultation because it seeks legal advice. So we'll have to discuss that later. So please continue to send in your questions. We'll do our best to address them when we're all finished. And we'll also take questions from those in the room. Kristen?
Great. Well, good morning, everyone. We definitely saved the most exciting topic for the last, the reporting and the audit, which, again, I would suggest that as we talk to company after company after company on this topic, after the first question, which is typically, is this going to go away, it quickly moves to, okay, once I try to figure out what this is going to entail, what's the end product going to be? And so I'll talk a little bit about the reporting side of the equation, and then in the event that as an organization you move to this step 3 of the SEC's rule and have to conduct the complete due diligence and potentially be subject to what's called an independent private sector audit, I'll walk through some of those considerations given the perspective that I bring as an auditor of non-financial information. So really there are 4 forms of reporting. There's this disclosure phase of the process, so that you move through this reasonable country of origin inquiry that has been described, and you make a determination that either the conflict minerals that are used in your products do not originate, and you have evidence to support that do not originate from these covered countries, or that they are from recycled or scrapped sources. But the fact that you've gone through this reasonable country of origin inquiry and come to that conclusion, you need to, as is listed here, comply with the disclosure requirement on this new Form SD that the SEC created. So it's disclose the determination of the reasonable country of origin inquiry, a brief description of the regional country of origin inquiry, and I will just echo the comments that were made previously that one of the key challenges here as you think about what is that form of reporting or form of disclosure that I'm going to have to undertake is that the SEC did not define what reasonable means. And importantly, they did not even prescribe what the inquiry process should look like. So again, as an organization is trying to keep the end in mind as they are undertaking the process, this is where there are significant challenges. What the SEC did say was that a company needs to take into consideration unique facts and circumstances for the company, a common refrain that we hear from the SEC a lot, as well as the existing infrastructure at the time. So as was mentioned previously, a lot of these industry initiatives that have been underway and focused on this issue for some time have really been advancing a lot of initiatives in the conflict-free smelter program, for example, a lot of the tools and just convenings in the region, various different initiatives that are really trying to create an enabling environment that will help a publicly listed companies, many steps removed from that region of the world, get to that conclusion in a more efficient manner. So it's important to recognize, but I think as was also mentioned, as Mara mentioned, there's a tremendous level of judgment and risk tolerance that has to be considered. While there are a lot of synergies from an industry perspective that can be gained, each individual organization is really going to have to make determinations and judgments, significant judgments based on their risk tolerance. So that's the first, and I guess you could suggest perhaps the easiest of the disclosure requirements if you know that you use these minerals and are subject to the rule. Now this slide is a tremendous eye chart. I recognize that and I apologize for that, but you have it as a reference in your materials. What it's just trying to do is provide a snapshot of, so once you move on beyond that disclosure side of the equation, if you determine that you do use these conflict minerals that are from the region, or you have reason to believe they are from the region, or are not from recycled or scrap sources, then there are three determinations or three designations that through your due diligence process that you will come to a conclusion around. So the first, so then when you move to this phase, which is the step 3 of the process, you've already had to actually, you understand that you actually have to do the disclosure on the Form SD, and then you actually have to create a conflict minerals report that will be attached as an exhibit to your filing of the Form SD. So it's actually a separate report. And what's included in this very, very illegible content here is really the elements of the reporting that the SEC established. One of the key questions that we hear from clients all the time is just what's the form of report? What's the standard form of report? Again, keeping that end in mind to inform my process along the way. Well, the SEC included elements of what should be included in the report, but didn't suggest a standard form. We all, in the environment of filings and disclosure to the public, like standard formats to help make sure that comparability and transparency and things like that. But I guess the first, just to walk through the three options quickly, the first option of not found to be DRC conflict free. So clearly this is the most comprehensive. You not only need to go through a description of the measures that your company has taken to exercise due diligence, and just to touch a bit on that, as we've talked about the 3 steps of the rule, and again, starting with the fact that under the step 2 in the reasonable country of origin inquiry, there's a tremendous lack of clarity or definition around what that really means and when enough is enough. But when you have indicators, you know that suppliers that you're engaging with in China, for example, have interests in the region. There are certain things that as you would go through a process, and really the phrase within the rule talks about if you have reason to believe. And so there's that evaluation process that you would need to go through that would really then position you or trigger the step 3, which is really thinking comprehensively about a policy to start out with, and how are you going to, as John was describing, undertake this engagement with your suppliers, and then what are you going to do once you actually receive responses back from these suppliers, or if you don't receive responses back from these suppliers, kind of what's your process that you will have in place, what's your due diligence process that will position you to understand, can I rely on these representations that I'm getting from my suppliers? That can include training of suppliers. It can include, practices where you take certain measures, and if certain steps are not responded to by suppliers, then you have, a process in place, a remediation process in place. So there are several different kind of leading practices that have emerged in terms of how companies can undertake this process. But at the end of the day, again, it's getting back to this concept of a reasonably designed and in good faith process. And that therein lies where the tremendous level of judgment. And from the auditor's perspective, as you think about the due diligence, it's all about, documenting first and foremost, and making sure that as with any other judgment that's made in general business reporting or any other types of disclosures, that considering all the relevant inputs that informed your decision. So thinking through the fact that an external, a third party, will come in and try to evaluate the reasonableness of that as you came to that reasonable conclusion. So with that, just as a little bit of the background on the due diligence process. So again, if you have, again, reason to believe that the minerals that you're sourcing or cannot determine that they are not from the region, or I'm sorry, after you've already moved into the region, but are not conflict free. So John showed us the snapshot of where we are in terms of this conflict free smelter program, which has really emerged as one of the leading practices that will help enable a company to come to that conclusion, because the certified smelter, it's gone through the requirements to ensure those steps of making or doing the best possible to determine that the smelter is not contributing to these militia groups through their purchasing and trade of these minerals. So again, the description of the due diligence, and there are three key elements, and we'll speak to the independent private sector audit here in a minute, but it very clearly in the disclosure, in the report, you need to identify the auditor that you engaged. You need to provide a copy of the audit report. I can't even read my own, the statement that you received or engaged for the independent private sector audit. And then in this case, you need to go to the level, and this is one of the multiple extreme challenges for companies, but of identifying the products. And so that's a big question for companies. Is it by product family? Is it by component part? Is it depending on the industry that a company works within? This can get just completely voluminous in terms of what could potentially be disclosed. Description of the facilities, and then again efforts to determine the mine location of origin. And again, through this conflict-free smelter program, the idea is those steps are taken care of, if you will, or certified based on the fact that the company or the smelter has been certified conflict-free. So it's moving to the right, the conflict undeterminable, DRC conflict undeterminable. And this is where was touched on previously, this idea of a phase-in that the SEC introduced in the final rule, which was one of the real steps that were taken, that was a welcomed change in the final rule versus the proposed rule. And this idea that in the first 2 years, large companies will not be in a position in many cases to come to a determination of either DRC conflict-free or not DRC conflict-free. And so this idea that there still introduces this reporting obligation where you still have to document and undertake measures, so the full due diligence process and the reporting process, you just don't have to seek the independent private sector audit for the first 2 years. I think was mentioned before that a lot of companies are just taking the assumption, and we hear this all the time, I'm just going to be undeterminable. I know that based on my operations and the extent of my global complex supply chain, there's no way I'm going to be able to come to a determination. And the one caution that we suggest as a company is kind of thinking through the process and almost presupposing the outcome for the first year or 2 years is that with the emergence of the conflict-free smelter program, in the event that in one of your product lines or through one of your suppliers, you actually can get back to a smelter that is a certified conflict-free smelter, then that triggers you to the third option, which is DRC conflict-free. And there again, the audit is back on the table. And so if you have 10,000 products and 9,999 of them through the supply chain, you just say, I can't get back to that level. But for the one product, you are able to get back to that conflict-free smelter. This is an extreme example, but just to highlight that this assumption going in that you're not going to, need to seek an independent private sector audit, well, likely will be the case in many cases, is not something that we would suggest is just assumed from the start. Okay. Oops. Okay, so again, another eye chart here, but again, you'll have it for reference. The point to highlight here is that within the SEC's rule, this idea of an independent private sector audit was introduced. Actually, it was introduced in the legislation. And the SEC made the determination that the GAO, so the Government Accounting Office, the standards of the GAO would apply and govern the conduct of the independent private sector audit. So as a part of that, they introduced this idea of two forms of audit. So an examination, attestation, or performance audit. And for those of you who deal with traditional financial statement audits, an attestation is very similar to a financial statement audit. It's coming to a reasonable conclusion and opinion, and may be performed only by CPAs, and results in a standard form of report. So many people are familiar with an audit report of financial statements. It's a very kind of standard set of language that draws to that opinion. The other option that was introduced is this idea of a performance audit, which many people are less familiar with in this context. So a performance audit is traditionally, it's in the context of government programs and government funding. And again, it's still seeking that reasonable assurance, but more so the reasonable assurance that funds that are directed towards a certain program or project are meeting their objectives and trying to seek reasonable assurance around that. So again, process controls, but very different from a traditional disclosure to a regulatory body and what an audit really entails. And so when you look, and just to jump back to the objectives of the audit, they're very, I guess, direct in the sense of, first and foremost, whether the issuer put in place a due diligence process that was in alignment with a recognized framework, so a national or internationally recognized due diligence framework, which the SEC cites the OECD due diligence framework for supply chains and conflict regions. And that's really the only comprehensive due diligence framework that currently exists. So that's pretty much the de facto framework. So again, whether you've designed your process in alignment, and then whether what you described in your conflict minerals report, you actually executed. So when you think about a traditional, think about 404, right? And the audit of 404 is not only design and implementation, but the effectiveness, the operating effectiveness. Well, in this case, the audit is unique because it's not even design and implementation. It's the design, and then whether you actually conducted what you said you did, you actually did. And so there's still some clarity that we all, as the CPA profession, are trying to seek out on that, and I'll touch on that, I think, in the next slide. Just the distinction to make, because the question automatically turns to, okay, if there's two forms of audit, is this my financial statement auditor? Does my financial statement auditor have to do this? Can they do this? Are there other providers that can do this for less expensive? The whole concept of the competitiveness. And the SEC clearly indicated that the idea of introducing the kind of optionality here was very intentionally to expand the competition and minimize the cost. So non-CPA firms can conduct a performance audit. Again, it takes a different form, especially in the form of reporting. So in the spirit of the law, the transparency and comparability of these disclosures to the market perhaps will be not achieved through a performance audit, but then we don't yet know what the reporting will actually look like. But just to highlight that the importance of the fact that a non-CPA firm can conduct a performance audit, but it's important that this firm also complies with the GAO standards from an independence perspective and a quality control perspective, which includes undergoing a peer review every 3 years, which includes actually seeking the professionals who would conduct this audit actually seeking certain CPE credits. So in the world of CPAs, it's CPE versus CLE, but continuing professional education to credentialize and ensure that there's a level of rigor and consistency in the delivery of these audits. So again, I know it's a lot of detailed information, but you have it for reference. And then I'd just like to conclude on this, the reference to the AICPA, so the industry group for CPAs, has convened a conflict minerals task force. And the idea was to, bring the auditors together and really think about the audit considerations as it relates to this rule. And it's important for a lot of reasons, in the sense that, if we think back to 404, not that we like to bring that scenario back up, but in the absence of prescriptive guidance to issuers, many companies just look to the auditors to set the standard. And what an intentional step that was taken was, the auditors convening, working closely with the industry groups. We've had various different engagement with the industry groups to understand that issuer perspective as the auditors. As the industry groups are trying to issue guidance, the auditors are also trying to issue some guidance to practitioners to try to, make this as practical and the ease of implementation to the extent we can. Just to reference representation on this group, again, this is the industry group of the CPA profession. So it's the traditional big four accounting firms, as well as a few others, so McGladrey, Grant Thornton, BDO, and then the GAO also has a seat on this task force. And I think that's really important to note, because the GAO is the governing body who actually, will have to enforce the standards against which these independent private sector audits will be performed. Just from a process and timeline, this AICPA working group, as I mentioned, we've been working with some of the industry groups. we've convened back in the fall and are looking to issue some guidance later this year, looking to host a series of webcasts, again, trying to get further information out about what this audit really means. Also, just a point on the SEC, and clearly, as we've reinforced over and over again, a tremendous amount of vague aspects of this rule, and the audit is no different. And so some of the points I've touched on, we as the CPA profession, as well as many other constituent groups, have recently met with the SEC and tried to just share what we're hearing in the marketplace, as well as the challenges that we're facing as an organization, needing to be prepared to actually conduct these audits and comply so we can help our clients comply. We certainly have indication that they are considering issuing additional guidance, as Mara mentioned, which will be much welcome. They'll certainly be focusing on guidance to issuers prior to focusing on specific audit considerations. But I think what's important is that the SEC reinforced the focusing on the audit objectives that I referred to on the previous page. And so that concept that I just described around design and implementation versus operating execution, that they are two very distinct objectives. So when you think about getting to the end game here, what is the reporting? What is the disclosure? And clearly, as an issuer, I want to make sure that my process and my documentation and my report are informed by what the auditors are going to be looking for to support that. And so more to come on additional clarity that the SEC could provide. But it is important to reinforce that there are distinct objectives, and it's not an audit in the traditional sense, is kind of the theme of this. And I think that's one other point I'd just make, again, just to illustrate the challenges, and again, we hope that we'll have some additional clarity from the SEC, but a disconnect between, as I walked through the previous eye chart around what's required, what are the required elements of the report, the conflict minerals report. There is a bit of a disconnect between what's required in terms of the description that a company needs to provide very specifically and what the audit objectives will focus on. So again, probably a level of granularity beyond what we need to get into today, but just to highlight and illustrate that there are some challenges that we're still further trying to work through with the SEC on this. I think that's it.
Great, thank you. These were great presentations, and actually the order worked extremely well because we heard from Mara on the general structure and some of the legal issues. John explained the way in which industry has organized itself, especially on supply chain management, a very complicated issue. And I was interested in John's comment that of all of his many supply chain challenges in the private sector over the years, this is the most complicated. And I think, just to build on one thought, a lot of the activity in this part of the world is going to be in the shadows. It's going to be through not formal record keeping in many ways. A lot of things are going to be done in parts of the world where the idea of complying with the U.S. law along these lines would be met with some suspicion. In the legal profession, we would call it extraterritoriality. In the business world, it would be like, what in the world? Like, why are you doing this to me? So I think that those are legit. And Kristen, as usual, laid out some of the how do we get there from here comments about how an auditor can contribute to the process, make it legit in the eyes of the SEC, but also in the eyes of the company. What kind of a plan makes sense? How do you audit the plan to see if it is consistent with expectations under the rules, but also did the company actually do what it set out to do, which is sort of in a superficial way, it's an obvious thing. You know, the company had a plan, but the idea behind the independent auditor looking at a company's action is to be sure that there's somebody outside of the supply chain folks in the company that are taking a critical look. And I think I think her outline was extremely precise and clear on that, and that was very helpful. So I'd like to conclude before we lose the connection with a thank you. Great panel, John and Kristen, Mara, obviously, and Sam. a lot of very important and difficult issues. This is a regulation that took 2 years to develop. I suspect it will keep unfolding month by month by month. There will be new questions and challenges. We're all spending a lot of time working on this and happy to help in any way as you all try to figure out compliance issues, whether you're a filer or a supplier, or in some of the folks who may have called in, an NGO watching to see how the private sector is reacting to Dodd-Frank and the implementing regulations. So you'll be getting a package of materials. Those of you that didn't get specific answers to your questions, feel free to get in touch with us. And thank you all for calling in and participating in person.
Manufacture or contract to manufacture. The conflict minerals are the 3 T's and G, which are tantalum, tin, tungsten, and gold. And the covered countries that people care about where they're from is essentially the DRC and then the surrounding African countries. There are some small exceptions. It doesn't apply if it's outside the supply chain prior to January 31st, 2013. And it doesn't apply if it's from recycled or scrap materials. But really, for most companies, the most complicated provisions are, if you're a manufacturer, again, it's pretty easy. If you're a manufacturer, you're covered if you're also an issuer. The contract to manufacture is one of the most contentious issues around because the SEC didn't really define what that means. So, if you require somebody to manufacture something to you, if it's something that's completely off the shelf, you don't interact with anybody, you just walk into a store and buy it, you're not contracting to manufacture. And then if you manufacture, that's on the other end, you're obviously a manufacturer. Anywhere in between is undefined, essentially. So there's a sliding scale of the more control you have over the content and the design of the product, the more likely you are considered to be contract to manufacture. But this is one of the really undefined areas, and it's a place where, for most of our clients, it's a combination of an interpretation of the rule and the risk tolerance of the company. So some companies want to aggressively exclude things from the rule, and they draw a line in one place. Other companies want to over-include just in case. And so we help them in both situations. The other issue is whether or not it's necessary to the functionality of a product, which is essentially if it's part of the function, use, or purpose. If it is intentionally added to the product, and if a conflict mineral is intentionally added to the product, then obviously it's covered.
Of this, and then turn the presentation to my panelists here. On August 22nd, 2012, the SEC issued a long-awaited final rule under Section 1502 of the Dodd-Frank Consumer Protection Act relating to the use of conflict materials. The final rule, which under Dodd-Frank should have been issued April 15th, 2011, is intended to reduce the flow of funds from the extraction and sale of certain minerals that have been used to finance armed conflict in the Democratic Republic of Congo, DRC, and surrounding countries by increasing accountability for parties involved in the supply chain for these products. And to give you some statistics, and we were talking in the room here in advance of the session of the huge impact of this very complicated rule, an estimated 6,000 companies will be required to file annual reports with the SEC to review their supply chains and publicly disclose their use of tantalum, tin, tungsten, and gold if any of those materials are necessary to the functionality or production of a product that they manufacture or contract to manufacture. Mara will be giving some of the details about the rule and an update on the current litigation regarding it. So I'll stop with my background, turn it over to Mara. And what I think is most efficient, I will just say a word about each of the panelists, and the order, we read Mara, John, and then Kristen. Mara Sen, Arnold & Porter partner based in the DC office, is a trial lawyer who focuses on white-collar criminal law, international arbitration, and other regulatory issues. She's litigated in the U.S. District Court, Court of Appeal, and the U.S. Supreme Court, as well as various international fora. Her practice is incredibly diverse, including issues of corporate social responsibility like the conflict minerals, to traditional litigation, white-collar litigation, and corporate compliance. So Mara will be able to give us an overview of the law and some of its implications. John Gabriel. sitting to my left, serving on the board of directors of the Electronic Industry Citizenship Coalition, EICC, and is the chairman emeritus of its board of directors. EICC is a 75-member global organization focused on a supply chain code of conduct and implementation tools for the electronics sector. John is also corporate manager of IBM's Supply Chain Social Responsibility Program. He was appointed to this position in January 2004 and oversees a global team responsible for IBM's Supply Chain Social Responsibility Initiative. Tremendous enterprise. And finally, Kristen Sullivan is a member of Deloitte's Sustainability Services and works with clients to help address their sustainability needs, focusing primarily on sustainability reporting and assurance matters. She brings extensive experience in sustainability reporting, specifically focused on social impact. Kristen, in fact, leads Deloitte's efforts in support of social impact investing, specifically focused on Deloitte's services in support of the Global Impact Investment Rating System, GIIRS. Significantly, for today's program, Kristen heads Deloitte's Conflict Minerals Advisory Services, so has particular insights and is a real leader in this field. And we're very happy to have both John and Kristen join us today. And with that, I'll ask Mara to go ahead and set this up.
Great. Thanks, everybody, for participating. And I'm really excited to be on a panel with these guys because the nice thing is, I'm a lawyer. We're kind of a dime a dozen, although I like to think I'm unique in some ways. But these guys really have actual knowledge. And John is even an engineer, so he actually really knows stuff. So, so what I'm going to try to do is just, for those folks who aren't as familiar with what this rule even means, I'm going to do an overview of the SEC rules, the current state, and then I'm going to talk a little bit about the current state of conflict minerals litigation, and then just talk about what it is that lawyers do in connection with these issues. I only have, I'm going to do a disclaimer, I only have 10 to 12 minutes, and Sam will cut me off if I go even a second over, so I'm going to try to, I might not be able to cover everything, but, we're happy to answer questions at the end. So as Sam said, this was a recently issued rule. Many people, including those in this room, question why it was even put within the bailiwick of the SEC. And really the answer is because Dodd-Frank was a huge monster and everybody else was completely filled up, and they said, let's just give it to the SEC. I deal with the SEC a lot on the FCPA issues, so I'm familiar with the way that they work, and they're not always the most effective organization, and I think that it's particularly challenging for them to deal with this rule, which is completely outside of their core mission, and has been very controversial. They took an extraordinary amount of time to even come up with the final rules, and then the final rules basically said we're not defining anything. So, those are sort of the overview of some of the complications. So the first step, if you're a company, is do the rules apply to you? The second step is that if you determine they do apply to you, you need to do a reasonable country of origin inquiry, and then step 3, you have to perform due diligence to figure out where they're actually from. Okay, so the first rule, does it apply to you? And this is the seal of the SEC, just, to make it legit. Okay. Okay, so step 1, are you covered? So basically you have to be an issuer, and some of the, we'll address some of the people who are not issuers, but will still be severely impacted by this rule. But in order to be subject to these rules per se, you have to be an issuer, and you have to manufacture or contract to manufacture a product for which conflict minerals are necessary to the functionality or production of that product. Now, each of those subparts of, if you're an issuer or not an issuer, presumably you already know that, so that's the easy part. The more complicated part is the rest of it. So
on to the beginning of the presentation. First, on behalf of my colleague Mara Sen and I, we welcome you to Arnold & Porter. We're very glad that you are able to join us for this program. The program is entitled What Your Company Needs to Know About the Current State of SEC Conflict Minerals Regulations. As we mentioned, for the 70 or 80 of you who are listening, please use the chat feature tool within WebEx to ask questions throughout the program. Due to time constraints, we might not be able to get through all of the questions, so please do not hesitate to contact any of us directly if there are things that weren't covered. Your lines have been muted, but if you need assistance during the conference, press star and then 0 on your telephone, and a conference coordinator will be happy to assist you. This event is being recorded and may be posted on the Arnold & Porter website, where it will be made available to the public. For your convenience, shortly after the program, we will send a link with the presentation materials to all of the participants of today's program. So on to our program. Those of you in the room have a booklet of materials with the slides that we'll be going through, and as I mentioned, we'll be sending them electronically shortly. Just to all of you who are on the phone, to set the stage a little bit for our presentation, I'd like to say a couple of words of background about the rules to put them in context. And I'm one of the few people that dealt with this issue while at the State Department. I was with the State Department for 22 years, and in 2 of my capacities there as a lawyer and later heading the U.S. refugee program, I dealt with the issue of displacement of people from Central Africa and some of the consequences of the violence. So it was a particular interest to me to come back into this issue from the perspective of the Dodd-Frank rule and the SEC's struggle over 2 years to develop its regulations. For those of you who are on the phone in particular, some of whom I understand may not have part of the history, I'll just read you about 30 seconds of history.